Tiernan, and we're very pleased and excited today to have so many people on this call. As chair of the Labor and Employment Law Group, along with my colleague Albert Lee, who will also be speaking today, I know firsthand the unprecedented challenges and issues that companies and HR professionals are facing as a result of the COVID-19 crisis. Our goal today and in subsequent sessions is to present and provide you with timely information on the rapidly changing landscape of human resources because of the pandemic. Before we get started, I would like to go over a few items. All of your phones have been muted, and you might want to double check to make sure that the phones are muted on your end as well. And we will have an opportunity to submit text questions to today's presenters by sending your questions to Allison Hurley. Allison's email address is ahurley, AHURLEY, at tuckerlaw, one word, .com. Let me go over that again. ahurley, AHURLEY, at tuckerlaw.com. You may send your questions in at any time during the presentation, and we'll collect these and address as many of them as we can in the Q&A session at the end of today's presentation, time permitting. Today's webinar is being recorded, and you will receive a follow-up email within 24 to 48 hours with a link to view the recording. So we hope that's helpful. Before we start some of the presentations on the substantive legal issues today, I thought that our listeners might be interested in a survey of nearly 150 employers and their employees that was taken by a local firm, JLL, to sort of gauge the return to work issues that are being raised both by employers and in particular by their employees. I thought it was revealing that companies are planning on average to only call back 20% of their workforces to see if they can, on a limited basis, successfully meet the Pennsylvania Department of Labor, OSHA, and other guidelines on a safe workplace. The first, of course, the issues of social distancing, installing clear signage on paths to use, restricting areas of use, use of restrooms, hand sanitations, and to see how through dialogue those procedures can be improved with employees. Also to the provision of protective equipment such as masks and cleaning protocols, and through communication and dialogue with those employees to improve and fine-tune the procedure. And that's why it's particularly important and one of our major topics here today on how to select and how to communicate and how to bring back employees to the workplace. The survey of the employees themselves showed that the following top 4 concerns expressed by employees about returning to work were as follows. The first was the issue of commuting. That was the #1 concern raised by employees. Some 66% of employees who use public transportation expressed an interest in potentially using some alternative means of getting to work. In addition, more than half the employees who have worked from home expressed an interest in continuing to do so, at least on some basis, after they return to work. So those are going to be initial issues that employers are going to have to work with and explore alternatives. They also expressed an interest in, secondly, in the sanitation and cleaning of common areas, not only the offices of their employers, but also lobbies and elevators of buildings that are shared with other tenants. And some studies have shown that just the use of elevators in a building could increase the amount of commuting time from a few minutes to almost an hour. So the whole issue of getting to work, and then even after you're at the workplace, getting to the building, into the workspace, is going to be a very critical one to people, and it has to be taken into account according to the survey. One of the issues, the third most important issue raised by employees, is what steps is the employer going to take to assure that employees or essential visitors who are ill or might have symptoms will not be on the work site. And there have been various options that have been explored by both the Pennsylvania Health Department. Many employers are very reluctant to use the taking of temperatures, but a number of employers are using the form of self-reporting and questionnaires with essential questions as a basis for at least initially trying to solve this issue. And then finally, how will the employers avoid having employees work in close proximity? What is the plan for signage, for restricting use of certain common areas like conference rooms, protocols for the use of these common areas or restrooms so employees can avoid violating the basic social distancing? So these are the concerns, and I'm sure all of you are struggling with them at this time to try to come up with the best solutions. I think employers are looking to have a dialogue, to have an ongoing, not just a communication, although initial communication is obviously critical, but to have an ongoing dialogue with employees so that these procedures can be fine-tuned and they can be improved as the workforce is gradually expanded. So our plan for today is to put a legal framework before you so you can help make some of these decisions that are soundly based in the law, but also can be effectively communicated and explained to your employees in a way that is convincing and also provides some understanding for them of the basis of what the employers are doing. So with respect to that critical issue of how employers can decide who to bring back to the office, I'm going to turn to my colleague, Attorney Scott Leah, and he can address that critical initial issue. Scott?
Thank you, Bob. So I'm going to talk about just that. You've survived the COVID-19 crisis so far. The business is still operating or ready to get operating, and you're ready to start bringing back employees who you've furloughed or laid off. And the question is, who do you bring back and when? And there's going to be a number of factors that you're going to be considering in that. One of the first factors, of course, is if you've received a PPP loan. As you know, if you receive one of those loans, you have a requirement of spending a certain amount of it, 75% on payroll expenses to get forgiveness. And you also have to have your full-time equivalent employees back to a certain level. I'm not going to go into depth in that because I think Albert Lee is going to be discussing a little bit of the loan forgiveness in his section, but obviously that could be a factor that you're going to be considering in how many people to bring back and when. Another one that, as Bob just mentioned, is the safe workplace. That's going to be a consideration as well. There's a lot of information out there being put out by the CDC and OSHA and some other governmental organizations about safe workplaces. And as you may know, that many of the suggestions that they have are trying to limit the number of people in your office at any one time, whether that be through having people put on shifts, whereas in the past everyone worked 9 to 5, perhaps having shift work, having more people telecommute, perhaps not bringing everyone back at the same time, shifting people to different offices, not having cubicles side by side. So there's going to be, that's going to be a consideration too, because obviously the number of people you bring back, you want to be sensitive to, are you also complying with the safe workplace suggestions and best practices as well. But what I really want to talk about, because Bob kind of covered that, and that's something you can look at and talk about later, but let me talk about some of the employment law considerations in bringing people back. What you need to realize is your decision as to who to bring back and in what order you bring people back is an employment law consideration. It is a employment decision. It's the same type of an employment decision as when you're deciding who to terminate. And as you know, when you terminate someone, there are certain risks that are carried with it, risks of claims against you for discrimination or retaliation. And those same risks apply in deciding who to bring back. In fact, in some ways, you have more risk because when you're terminating someone, you always have the option of offering them a severance agreement and a release of claims at the time of the termination. You're not going to have that when you bring them back. So if you're not planning to bring everyone back at the same time, and many aren't, if you're going to slowly bring back your workforce, you're at risk of some potential claims. One of them is discrimination. Your typical claims for discrimination are things such as race, age, gender, disability, religion. Those are the type of wrongful termination, discrimination claims that employers can face when they make an adverse employment decision. I want to talk about a couple of those that I think are the most acute in this situation, the most likely to arise out of your decision as to who to bring back in this coronavirus era that we're in. One of them is age and disability claims. Some employers may decide on who to bring back in what order, and they may take into account age. Their theory may be that because there's no vaccine right now, no cure right now for coronavirus, and they have a concern about protecting employees, that not calling back higher risk employees first makes sense. And they may say anyone over a certain age is at higher risk, anyone with a certain disability, physical condition, perhaps is at a higher risk, and they may feel that it makes sense not to bring those people back first. And an employer may do this out of what they think is a common sense approach. However, if you just assume that an older worker does not want to come back, or assume that a worker with a handicap or a disability does not want to come back right away, and you make your decision based on that, you will open yourself up to a potential claim that you have discriminated based on age, or you've discriminated based on handicap or disability. So I think while it seems to make some sense to do it that way, you certainly are exposing yourself to some potential risk if that is your deciding factor in who you bring back. Another that some employers, and I've had some calls on this, is there's a gender issue here. I've had some employers suggest to me that they think that their employees with young children probably don't want to come back first. They may want to stay home with their children longer. Perhaps daycare is still not readily available. Schools are still not in session. In fact, will soon be out for the summer, even if they were in session. But again, if they make the decision that those with young children, or more specifically, often mothers with young children who often have the role of caregiver, do not want to come back to work first, again, they've opened themselves up to a claim of some sort of gender discrimination claim. So I would caution, you don't want to make your decisions based on anything that could lead to one of these discrimination type claims. Age is a common one, as I said, handicap, gender, you don't want to do that. Second type of claim you could have by an employee, because let's keep in mind, some employees want to come back and will be upset if they don't come back now. Some employees don't want to come back, and Albert Lee is going to cover what to do with those employees. But I'm dealing more with those who want to come back, but they're not the first ones on your callback. You're bringing back 50% of your workforce, and some of them don't get called back first. So discrimination claims is one risk. Also be sensitive to retaliation claims. A decision on who to call back can lead to that. There are different types of retaliation. If you've had some employees apply for unemployment compensation and other employees have not applied for unemployment compensation, those who applied and received benefits could feel that you're retaliating against them if they see someone called back who did not receive benefits. And I'm not saying you made the decision based on that, but this is perception often on the part of employees. So you want to be sensitive that that's not in any way part of your decision making. Some employees may have taken paid leave or unpaid leave, or paid or unpaid FMLA leave. Again, they're going to be sensitive to potential retaliation claims. Some employers are not happy when someone's taken that type of a leave, and you certainly don't want your decision making to be based on whether or not they took that leave, or even to appear in any way that it was based on whether they took that leave. Further, as you may know, and I believe Albert's going to cover as well, the paid time off under the Families First Coronavirus Relief Act, the sick time and the paid FMLA, that bringing employees back as he will talk about, will make them eligible for. For the part of what I'm talking about is that should not be a consideration on who to bring back either. You do not want to delay bringing someone back under the theory that if I bring them back, they're probably going to request paid time off or paid family leave. And it might, again, make some common sense. You're bringing back 50% of your workforce because you have 50% of the amount of work. And if 2 people take paid leave, they're not working. So it doesn't do you any good to bring them back if they turn around and just go out on leave. But again, that can't be a basis of your decision because it could look like you're interfering with their rights under federal law. They have the right, when called back to those paid leaves, if they qualify, and you don't want to appear as though you're interfering with that by not calling them back so that they can't request that leave. So the best practice is to not allow things like that to have any part of your decision making, and not even to ask employees. Certainly don't ask them, if I call you back, are you going to take paid leave? Or are you going to need paid leave? Are you going to need paid FMLA? That is a slippery slope that you're going to get into if you even ask them the question, especially if you decide not to bring them back right away. They're going to think that had something to do with it. Another area I want you to be sensitive to is whistleblower claims. Traditionally, whistleblower claims are things where someone's made like an OSHA complaint or perhaps a financial irregularities. Maybe they've made a complaint that someone is sexually harassing someone. Well, you could be open to a whistleblower claim and decisions of how to bring people back and when. If you have an employee who has made complaints about safety in the workplace, especially relating to COVID-19, such as someone who has complained that appropriate PPE are not available, they want certain types of masks or things like that, or they've made complaints that sick employees have not been sent home, or that they're not being tested, or customers are not being kept separate, the facility is not being properly cleaned. Any type of complaints like that by an employee, either prior to their being laid off or furloughed or even during, you need to be sensitive that they may see themselves as a whistleblower. And if they do and they're not brought back right away and you can't show the reasons why, they may feel it was because they've made those complaints and you're retaliating against them. So I think you want to be careful about that. Additionally, if you know that employees have been discussing among themselves these types of issues, whether, you know, what the safety requirements and cleanliness that you're doing, whether whether you're taking temperatures, things like that, that could be considered to be a concerted activity by your employees that's protected under the National Labor Relations Act. And if it looks like you are retaliating against those who are the ringleaders of that, or those who have taken place in those types of discussions, that could cause you to have a problem. Some people think the NLRA only applies to union companies, but it doesn't. While much of the National Labor Relations Act has to do with unions, it applies to all businesses. And so to the extent employees are involved in what could be seen as a concerted activity, such as complaining about these workplace conditions and what you are or aren't doing, that could lead to some liability as well if you take a retaliation against them. So having discussed these potential claims against you, discrimination, whistleblower, how do you avoid that? How do you call people back and not have those types of claims made? And let me give you a couple of ways you can do that. First of all, if you have a collective bargaining agreement with any of your employees, if you are, in other words, a union employer, then you need to look at the collective bargaining agreement itself and have your attorney look at the collective bargaining agreement. They often have specific callback procedures set forth that you have to follow. And should you follow those, you're really insulating yourselves against claims because you're following what you're required to do, at least for those union employees. Now, there may be some leeway in it, and that's why I suggest you have it looked at, because there may be some needs of the business that can trump what the CBA says. But you obviously have a CBA, and I know not everyone does. Most private employers don't, but that should be a first place you look. Second, do you have written policies? do you have any written policies already in place that govern layoffs and furloughs and callback rights? If you do have such a policy, then you want to review those, and perhaps have your attorney review those, and you want to follow those. You don't want to have a written policy in place that you do not follow unless you have a very good reason for it, and perhaps you do based on hardship to the business or this an undue burden or something like that. But again, I think that's something, and again, I don't know how many would have such a policy, but if you do have such a policy in a handbook or something like that, then I think that's something you want to review and have someone review for you. A third possible consideration are any promises you made. When you laid off or furloughed people, did you make any promises to them as to callback? Did you tell someone, hey, I've got to let you go, but you're going to be the first one I call back, don't worry about it? If you've made that type of a promise, and hopefully you didn't, but if you did, you might want to consider keeping your promise, because you could have an individual who's very unhappy if you don't keep that promise. And as well, if you need to show why that person came back first and how you made the decision, you have a reason that you made a promise. But again, I think that's probably not going to be the case. So I think most of you probably don't have CBAs, written recall procedures, and you didn't make specific promises. So what do you do? How do you decide? Well, the number one thing you need to do is have a plan in place for who to bring back and when. You can't, if you're not bringing everyone back at once, which you could, maybe at reduced hours, if it makes sense for the business. But if it doesn't, and you're just going to bring some people back, have a plan in place for how you're going to do it, that you have thought out carefully, discussed among management or ownership, perhaps discussed with your legal counsel, and then you have a plan that you can follow. Some of the ways that businesses are deciding who to bring back are these. One way is seniority, bringing back those with the highest seniority first. That's very much a way that you often see in a CBA, in a collective bargaining agreement, often seniority first. And that's a very acceptable way, if you decide that makes sense for you, is we're going to bring people back based on seniority. Performance is another way you can make your decision. You can choose performance, those with the best performance, your top performers, you're going to bring those back first. Now, I'll caution you is, what do you base that on? How subjective is that? Do you have performance evaluations that you could show that you brought back those with the best evaluations? And are those accurate evaluations and not, sometimes those are inflated? But performance is certainly one way to do it. It makes some sense that you're going to bring back your best performers. Another way you could make the decision is by department. Not every business ramps up every department at the same time. Some areas of the business may be busier than other areas initially, and some slower. If you anticipate that, it may make sense to bring back certain departments first. Again, if that makes sense for your business. The needs of a business are always an excellent way to make a decision and help to insulate you against liability. So that could be, you could be bringing back departments. Or, and it's similar, it could be specific jobs or positions. Perhaps you don't have departments, but you have specific jobs that you know you need now over other jobs that you'll need later. And if that fits the needs of your business, again, that might be the basis for your decision. It could be locations. If you are a business that has more than one location, you may ramp up one location faster than another location and bring back the employees of that location first and the employees of other locations second. Or maybe a final way might be employee choice. In other words, volunteers, like those come back first that want to come back. And that's some of those things I talked about earlier. Some people may feel at higher risk, or because of childcare, they may not want to come back first. But does that fit the need of your business? I wouldn't say to do that if it doesn't fit your needs. And so I think that could be a way to do it, but you've got to be careful with that way as well. But the important thing and the overriding thing I want you to leave this session with is the idea that you need to have a basis. It needs to be thought out. And the more documentation you have of the decision you made and why, the better, because it's something that you can show if need be, if someone claims a discrimination or retaliation against you, that you have this legitimate non-discriminatory reason, well thought out, documented for how you're going to do it, and then follow it. It doesn't have to have the procedure in place if you don't follow that procedure. So you want to follow that procedure as well. And you may want to, once you have that procedure in place, let your employees know, here's how I'm going to be bringing folks back, so they're not left wondering. And so that's essentially, I think, my tips. I would say, again, consult with your legal counsel if you have one on your plan, but have a plan in place and follow that plan, and that can help insulate you from the potential pitfalls and traps of liability on who you bring back. And with that, I'm going to turn it over to Albert Lee, who's going to talk about some very important issues.
Thank you, Scott. This is Albert Lee. Thanks, everyone, for joining us. I cannot emphasize how important it is to consider the tips that Scott just gave. The idea of making sure that your decisions about who to bring back first, who not to bring back, when, how, under what conditions is critical. I want to highlight the word that Scott used the most. He used the word need over and over and over again, and that's not a coincidence or by accident. Anything that you can tie back to a business need. We're ramping up this production line before this one because of the demand from customers. We're going to do this part of Pennsylvania first as opposed to another part. Anything that ties back to a need is a wonderful inoculation against any accusation that you made a decision for a non-business reason, like an assumption about someone's health or an assumption about someone's sex. So the critical thing is to make everything tie back to a business need, resist the temptation to be clouded by or overly influenced by the other factors that Scott mentioned. Don't allow yourself to look outside of your business needs and your business concerns towards, for example, your assumptions about individual employees. Scott gave some great examples about that. To build on that, for example, I have had clients kind of ruminate about who they're going to bring back, and again, they're exercising what they think is common sense. They're trying to be human. They're saying, you know, we shouldn't call Albert back in the first wave because we know he has asthma, and there's no way he'd want to risk coming back. You know, we all know Katie's nearing retirement age, so I'm sure she'd just rather stay home and finish collecting her UC, and then she'd be months away from retiring anyway. Don't do that. Do what Scott said. Focus on the business, functional, operational needs. Now, my part of today is what happens next. Once you have decisions that you make about who to bring back when, in what capacity, what your work environment's going to look like Bob said about cleaning and so forth. Once you make those decisions and once you communicate those decisions to these employees, hey, Albert, we're touching base with you. We're going to reopen on this date. We want you to be part of the crew that comes back first. Your first day will be this day. Once you start communicating the decisions that Scott has talked you through in making, what do you do with the responses? We all know that we're going to get a wide range of responses. As both Scott and Bob talked about, your employees are not a monolith. Some of them feel very differently about what's happened and what's going to happen than others. Some people are dying to come back to work, and some people are extremely concerned about doing anything, about leaving their house. So you're going to get a wide range of responses. The easiest one to handle, of course, is yes. If an employee says, yes, that's great. I'll be there on Monday, and I look forward to following all the procedures you set up about hand washing and distancing. That's easy. However, as we all know, in this world, in the HR world, we rarely deal with just easy answers. So I'm going to talk about all the different non-yeses that you might get. And there's a lot of different kinds. And the central message from me today is that not all no's are created equal. It's really important to do some slicing and dicing. So you can't handle all the different responses other than yes the same way. So let me walk through all that. And like Bob and Scott did, I'm going to start out with some general principles here. As a general rule, of course, employers are broadly permitted to require employees to do things oftentimes that employees don't want to do. Whether it's work hours, duties, wearing uniforms you might think look goofy, working under conditions that aren't exactly what the employee would prefer. So the general rule is that employers are permitted, have a lot of discretion to tell an employee what the employer's expectations and directives are, and employees must follow them. The exceptions are, of course, are where the further digging needs to take place. So some common categories of exceptions are if the employer's expectation or directive violates a contract term. So as Scott mentioned, if you're in a union environment where you have collectively bargained a union contract, that contract is binding, short of some very, very narrow exceptions or things that you might be able to use to argue that you don't have to follow something you agreed to. You have to live up to a contract. So many union contracts are very specific about what you can ask a particular employee to do in terms of their duties, in terms of their hours, their length of their shifts, and so forth. So exception one is when your expectation or directive violates a contract term that's been agreed upon. Another key exception is if the thing that you're asking someone to do butts up against a legal right that they have. So, for example, and we'll talk a lot more in detail, the Families First law that Scott had alluded to is a very recent law, a law that passed just about a month and a half ago, specifically to deal with coronavirus issues, that give people not only a right to not be at work, for example, if their kid's school is closed and nobody else is able to take care of their child, they now have a right to go to not work, and if they can't telework, they have a right to be at home and not work, and on top of that, be paid. So that's just one example. We are all familiar with lots of long prior to coronavirus laws of the same ilk. For example, FMLA. FMLA is a law that if you are a big enough employer, you have an obligation to provide covered employees up to 12 weeks a year of time away from working, not working, so long as they meet all the requirements of a particular FMLA criteria, like, for example, their own serious health condition, to care for a close family member with a serious health condition, certain military obligations. So the general concept of laws that trump or create an exception to this general rule of being able to require people to come in when you want them to come in and do what you want them to do should be very familiar to you. But we'll go into some of those details as well. So the big issue here, of course, is that not all no's are created equal. So if you ask someone back and they say some version of no, I'm not coming back at all, or I will come back if, that's when it gets interesting, and that's where we have to figure out which category of no are there. Some no's are legally protected, and some no's are not. So here's some common examples. Let's say you tell someone that you're looking forward to getting them back in the office next Monday, and they say, thanks for reaching out. I'm glad things are ramping back up, but I can't come back on Monday because one answer might be, I have lupus and I'm on immunosuppressive medications, and my doctor has told me not to come to work. Or someone could say, I'm perfectly fine, but I live with my 85-year-old grandmother, and she has been successful over the last 7 or 8 weeks with us all staying inside to avoid any issue that would be a real problem for her at her age and give her other conditions. And I live with her, and I don't want to bring it back into her. You could get someone say something much more broad, like, I don't have any particular health issues, but I'm just very nervous. I don't even do my own shopping. I'm so nervous. Why would I come in? Particularly because I've shown you that I've been able to work remotely for the last bunch of weeks, or some version of that. I'm nervous, and I just think it's too soon. Someone could say, like I mentioned before, I have a young child. My child is still learning remotely from school. I don't have anyone else to take care of this child. My spouse works as a an essential worker at a life-sustaining business, and so there's no one else to take care of this child. And if you bring me in, I don't have a way to take care for this child. Someone could say something very candid and blunt, like, "Hey, it took me 3.5 weeks to finally get on unemployment. I'm now making more on unemployment than I would be if I'm working. I love the work, but if not everybody is coming back, I don't want to be the first. It took me so long. I fought very hard. In fact, I've been approved. I haven't even got my money, and you're going to bring me back." So I think employers can expect all of these possible types of responses. So what do you do with that? The important thing is to sift the answers that you get back, other than yes, into 5 distinct categories. So if you're keeping score at home, let's number them. So number 1, once you get a not yes, you absolutely can ask why. That's it, just why. It doesn't give you license to have a 3-hour conversation about everything past that, but you should certainly make a initial inquiry as to what the basis of their no is. And based on what you hear, put it into these 5 distinct categories. So number 1, is the reason that you're giving a reason due to that employee, that individual's health condition / disability? So using my examples before, if it's I have lupus and I'm on immunosuppressive medications, or I have asthma, if they raise their own health condition, you are in a category that could be very heavily regulated. And most of you on the phone realize what that category is, and that is that there are lots of laws like FMLA, like the ADA, the Americans with Disabilities Act, and other state and local leave laws that, as a patchwork, cover situations where someone is unable to work or do some part of their job due to a condition of their own. So once you get here, you're not too different than where you were prior to coronavirus. Most HR departments, HR functions have in place, long before coronavirus, a way to deal with people who say that they are unable to do all or part of their job due to their own condition. So, for example, and this is important, as a subcategory to number 1, if it is due to their own condition, it's really important to know whether the employee is claiming an inability to do all of their job or just parts of their job. If someone can't do any parts of their job, no matter what accommodations you make or don't make, the ADA is typically not an issue. The ADA typically protects employment rights for folks who have a disability but are still able to do some parts of their job if you give them an accommodation. Employees who can't do anything or are totally incapacitated due to their own condition, those employees could be protected by the FMLA. And if you are large enough, you have 50 employees within a 75-mile radius, you typically know who you are. If you are an FMLA-covered employer and someone has come to you in response to your offer to bring them back and indicated that they believe they are totally incapacitated due to their own condition, then start turning the FMLA crank. You probably have an FMLA function, or you outsource it, where you can ask for a physician certification. You can get medical information that documents someone's condition to the point where you can determine whether they're covered by the FMLA. Now, if they claim they can do some of their job, so for example, they say, well, I definitely want to come back, but I won't come back in the office. I want to be able to work at home 3 days a week because of childcare issues or my health. Again, you slice and dice. If it's their condition and they're asking you for an accommodation due to their condition, there's a separate ADA process called the interactive process that is very, it's mandatory and it's very regulated. You go through that process, and out of the bottom of that process comes a determination about what this person's condition is in terms of meeting the disability standards. You don't need to know what it is from an organic medical perspective. Don't gather detailed private information about the condition itself, but gather information about the functionality, whether the person can do all parts of their job except the part that requires them to lift, for example, 50 pounds from floor to table height. And then do the interactive process to determine if there's a disability, whether that disability can be accommodated such that the person could do their essential job functions. I'm using all the words that you recognize from an ADA perspective. Okay? Now, other issues under this first category are state and local leave laws. If you happen to employ employees who work in the city of Pittsburgh, even if you're outside of the city of Pittsburgh, we are all aware of the Pittsburgh Paid Sick Leave Act that was passed years ago, but recently reanimated last year by the Pennsylvania Supreme Court. That came into effect literally 4 days before Governor Wolf's stay-at-home order, so some of you may have forgotten about it. But as people are coming back, it's very important to, if you have employees who work inside the city of Pittsburgh, even if your main office is not, there are lots of requirements under that Pittsburgh Paid Sick Leave Act in terms of making sure employees accrue paid sick leave for the time that they work inside the city or how they use it. As explicit use of Pittsburgh Paid Sick Leave is for your own condition as well as to care for someone else with a condition. That could come into play. The recent Families First Act talks specifically about people's right to miss up to 2 weeks for full-time, 80 hours. If that person has been subject to a quarantine order related to COVID, or that person is exhibiting symptoms and is waiting diagnosis, that person has been advised by a healthcare provider to self-isolate. So again, all under kind of bucket one, reasons related to someone's employee's health, you have to sort out FMLA, ADA, Families First, Pittsburgh Sick, and any other kind of these leave laws that might apply to you based on your jurisdiction, where you are, your industry, et cetera. That's the first line here, because if someone has a legally protected right, then you really can't argue with that no, and you have obligations, for example, under FMLA and ADA. So bucket number two, if the issue is not, if the no is not related to the person's own condition, is it related to the condition of somebody else? So for example, I'm fine, but I need to stay home and take care of my mother, who is a high risk group, requires care because of being quarantined. Based on the Families First Act, that could trigger one of the 6 kind of new reasons that's created as a reason why people are permitted to not come to work, and in addition to that, get paid for a period of time. FMLA is the same. FMLA has always provided people protected leave as long as the employer is a covered employer and the employee qualifies. That person has a right to miss up to 12 weeks a year for reasons including to care for a close family member, who has a serious health condition. Pittsburgh Sick Leave also creates a right to miss work to care for somebody. So it's similar to number one, except that it's a little bit more narrow. Having someone else's health condition be the reason you're not at work does not trigger an ADA accommodation obligation. You can treat them disparately because they're associated with someone with a disability, but the obligations are less. So that's kind of bucket two. So once you figure out that this is not due to the employee's own health condition, go to whether it's due to someone else's condition in a way that specifically trips one of the trip lines in laws like the FMLA, the Families First Act, state and local laws, et cetera. So number three, is a situation addressed in a contract? We touched on this earlier when we were talking about Scott's discussion about bringing people back. But once they're replying to yours, if they raise an issue like, no, I shouldn't be the first people back because the union contract that I am a party to, because my job is within the bargaining unit, says that callbacks need to be done by seniority or by department seniority or whatever. A contract issue is a legitimate basis for someone potentially saying no if the contract applies. So if you are in a union setting, for example, heed Scott's advice about making sure you take a good hard look at the parts of your contract that could be implicated by a return to work. So that's kind of bucket number three. So number four is whether or not the idea of missing work or not being at work or saying no to you is something that the employee is allowed to do under a benefit or plan or policy that you've created. So, generally speaking, employers generally don't have an obligation to have certain vacation plans or PTO, but most do because it's good for retention, recruitment, and all that. But once you create a policy, you're typically obligated to follow the terms and conditions of that policy until you change it. So if you have previously, long before coronavirus, said that we have PTO because from time to time people get to not come to work, and if your policy allows people to have a great deal of discretion about when they miss work, they don't have to prove they're sick or bring in a medical excuse. They can miss work if their car doesn't start or if their hot water heater breaks. Don't forget that those exist. Even in a time like this, if someone is trying to not come to work and they're invoking a right that you've given them under the policy, it's really important to make sure that you don't try and divest someone of a right that you've given them. Now, that doesn't mean you can't change your policies prospectively. If these situations, I'll touch on this a little bit next, but we all get how this situation is unprecedented and crazy and different and not expected. We may want to look towards expanding or tightening up policies that we've previously put into place because of business need. But that's number 4. And I guess just to recap, so if someone says some version of no, some not yes to being called back, look at whether it's due to their own condition, look at whether it's due to someone else's condition in a way that's relevant to the rights that they might have through a statute, like at the FMLA. Look to see whether it's governed by a contract, like a union bargaining agreement, and then look to see whether it's covered by an existing plan of yours, because as Scott says, things that you say you're going to do are important to do. It doesn't look good, and there could be legal ramifications. So that leaves us with number 5. The last thing is, if none of the above exist, if there's no contract or other legal obligation or a plan or policy you've created that protects someone's right to say something other than yes, then you typically have extremely broad discretion to require people to come back to work in the manner that you want. Now, that doesn't mean you can't create, for these extraordinary circumstances, an exception to that. If you're sensitive to the person with a grandmother, if you're sensitive to some circumstance of theirs or their fear about public transportation, and you want to be more lenient about that, even though the first 4 situations don't kick in, you certainly can. And I've been talking with a lot of clients about, can we create a policy just for coronavirus that allows us to appear to be, not just appear to be in actuality, be very sensitive about the various things that people are going through. So that's it. That slicing and dicing is so critical. Employers who kind of mush everything together, every no in the same batch, and try and say, well, you have to come back. It's insubordination if you don't come back. Your job won't be here, is going to miss some situations that there are legal obligations to act in other ways. So that finishes my part in terms of what to do once you start getting answers back from employees upon calling back to work. I'll touch on one more topic before I hand it off to my colleague, Katie, and that is PPP loan-related issues. I know not everyone on this call may be a recipient of a PPP loan, but since it ties into our general topic and a lot of people are affected, I just want to give a little comment about this. The Payroll Protection Program, as part of the CARES Act, it created an enormous loan that's different than most loans most of us are going to see in our lifetimes because it's forgivable if certain conditions are met. It's targeted to, quote, small employers, unquote, those typically under 500 employees. But the conditions for getting the loan and for ultimately getting the loan forgiven are understandably causing a lot of employers to be concerned. So I don't want to go into too much detail because I know it doesn't apply to everybody, but let's talk about 4 sub-issues here. So number 1, it's critical if you're a loan recipient to use the loan money in the right way. It's really critical to use the money only for what are called qualifying operating costs. And there's two subcategories. So qualified payroll costs, and non-payroll costs. These are extremely narrowly defined. There's potentially some clarification due from the SBA and the Treasury Department, but in the statute itself, it carves out payroll costs being things like compensation, things like commissions, things like healthcare premiums that employers pay for group health plans, retirement plan contributions, things of that sort. Non-payroll costs are things like rent, mortgage interest, utilities. Like I said, there's still a lot of question about the details. You have 8 weeks to spend the money. It's not entirely clear if you have payroll costs that bleed in, that started before the 8 weeks and bleed into the 8 weeks, how that's going to be handled. There's some language in the law itself that's not clear. We're waiting for some clarification through regulations that we were actually expecting 2 Sundays ago. So keep an eye on that. So that's issue 1, is spending the money right. Number 2, make sure that at least 75% of that money is spent on the payroll cost side as opposed to the non-payroll cost side. Scott mentioned that, and that couldn't be more important. That could put into jeopardy the amount of the forgiveness that you're entitled to get. Number 3 is meeting the so-called headcount and payroll tests that decide whether your forgiveness is going to be reduced. So the law talks about looking at what your essentially pre-coronavirus headcount is and compared to now, and also with your payroll, to see in a rough sense whether you have remedied with this money any cuts, furloughs, layoffs that you took during the coronavirus crisis, whether you fixed them in some way, and same with any paid reductions. Those tests, the details of how those tests work are not out yet. Those are part of the regulations that are being closely awaited. So what we do know is there are comparison periods, look-back periods, time periods. Those are already kind of defined, but in terms of how you actually do the blocking and tackling, we're awaiting further guidance. And the last subject is the law talks about kind of a exculpatory situation where even if you made cuts already, both in terms of headcount and wages, you can have that not affect your payroll, your forgiveness of the PPP loans if, I'm using the words from the law itself, if those headcount and wage reductions are, quote, eliminated by June 30th, meaning fixed, June 30th, 2020. We don't know exactly how that's going to work or how that looks like. But those are the general things. I know there's a lot of other discussions about the PPP loans right now that are a little bit beyond the scope of this. But certainly, in terms of bringing people back, you can see the third and fourth parts of what I just mentioned, the headcount payroll test, and then this exculpatory bring people back and all will be forgiven, can weigh in, as Scott mentioned, in your decision on who to bring back. So with that, I will turn it over to my colleague, Katie Janosko, who will talk to us about unemployment compensation issues.
Thank you, Albert, and good afternoon, everyone. Tied directly to what Albert discussed about how some employees want to return to work and some do not is the issue of unemployment compensation. Now, as we all know, a major result of the pandemic has been a surge in applications for unemployment. The latest statistics show that in the last few weeks, 1 in 5 Pennsylvania workers has filed for benefits, and that likely includes some of the employees of our listeners. In addition to standard unemployment compensation, which is governed by the Pennsylvania Unemployment Compensation Law, the Federal CARES Act provided for what's known as pandemic unemployment assistance. This loosened the eligibility requirements and allowed independent contractors and gig workers to receive benefits for the first time. On top of that, it allowed for an extra $600 per week disbursement to all individuals receiving unemployment compensation from their state system. This extra $600 per week will continue to be available to applicants through the end of July. This afternoon, I want to discuss 3 concepts with our listeners who may be dealing with a firestorm of questions about unemployment compensation from their laid-off employees. So now that you remember these tips going forward to deal with the firestorm, I'm going to refer to them by an old fire safety technique that we all learned as kids: to stop, drop, and roll. Again, with respect to your unemployment compensation questions, I encourage you to stop, drop, and roll. Stop means to generally stop advising your laid-off employees about their unemployment compensation claims. Drop is a reminder that if an employee refuses to return to work when you call them back, they can be dropped from unemployment compensation, and you are obligated to report their refusal to return. Roll is a recommendation to roll out some new required notices regarding your employees' rights to unemployment compensation, which have become required following the passage of a new law about a month ago in Pennsylvania. So let's go back to our first recommendation: stop. Pennsylvania's Unemployment Compensation Bureau, I'm sure everyone on this call has heard, is currently overburdened by the increase in applications and calls from people who are requesting assistance. Officials are fielding, it's been reported, up to 20,000 calls per week. So it's understandable that applicants are becoming frustrated with the wait times and are seeking out information and advice about unemployment from any source that they can get. If you, as an employer, have had to lay off or furlough employees due to the pandemic, your employees might be tempted to reach out to you for a sympathetic ear to discuss their issues or to ask for advice on their application for unemployment benefits. It's our recommendation that you stop providing any advice to them about unemployment. Your role as an employer in this capacity of the unemployment compensation realm is very limited. You are not equipped to speak for the Unemployment Compensation Bureau as to whether your employee's application will be accepted, whether they'll qualify for benefits, or when they'll start to even receive money. You also do not want to find yourself in a situation where it appears that you are acting resentful toward those who exercise their rights under the unemployment compensation law to apply for benefits. You also want to avoid the appearance that you are giving advice on applications to some furloughed employees and not to others. So if employees reach out to you while laid off or on furlough to ask questions about their unemployment, we recommend that you be honest, be kind, and provide truthful but brief answers, but in the end, advise them to seek help from the Unemployment Compensation Bureau's online resources or from their own private attorney. Although you might feel sympathetic to them, feel guilty for having to lay them off during this difficult time, under no circumstances should you offer to contact the Unemployment Compensation Office on their behalf or to file a claim on their behalf. So the first concept is to stop. The second is to drop. Employers should be aware of how to handle a situation that we expect will become a lot more common following the resuming of normal business operations. As Albert discussed, if you call employees back to work, some of them might be hesitant to return. That might be because they're afraid of getting sick, or frankly, like Albert mentioned, it might be because they're simply making more money than their average paycheck with the extra $600 per week that they're receiving of pandemic unemployment assistance. The Pennsylvania Department of Labor and Industry recently made clear its long-standing rule that if an employee refuses to return to work, they will be dropped from unemployment. That's the drop concept. If they do so, they'll be considered to have quit their job. The unemployment compensation law in Pennsylvania at Section 402 is clear that if an employee is ineligible for compensation in any week in which their unemployment is due to failure to accept suitable work. And that is provided that the employer who offers the work notifies the department of their refusal within 7 days from when the offer is made. There's a form on the Office of Unemployment Compensation website. It's identified as Form 1921W. It's like right at the top of their website right now of COVID resources. and it directs that you as an employer should complete this form and submit it to the Bureau within 7 days of any employee's refusal to return to work. This is to affect their eligibility for benefits. And along those same lines, if the Unemployment Compensation Office reaches out to your business directly to verify the status of a worker who's receiving benefits, you're obligated to answer honestly as to whether the person is still laid off or whether you have called them back to work or made any attempt to contact them with respect to returning to work. So that's the stop, that's the drop. Last and not least is roll. So if your company had to make the difficult decision to lay off employees because of the pandemic, the next thing you have to do is roll out some new required notices to your employees. On March 27th, Pennsylvania enacted a new law known as Act 9 of 2020. Act 9 added a new section to the Pennsylvania Unemployment Compensation Law, which requires employers to notify a separating employee of the availability of unemployment compensation at the time of separation from the employer. So it's a required notice to show the availability of unemployment compensation. The notice must also contain details that the employee can apply for unemployment immediately. It must have information on the Pennsylvania Unemployment Compensation website and the office's toll-free telephone number, and also some of the required information that that employee is going to need to apply for benefits, including their social security number, and if they're not a U.S. citizen, their authorization to work in the United States. Tucker Arensberg's Labor and Employment Group created a generic notice for employers to use, which sets out all of the information required by Act 9 to be given to separating employees. Also, the Unemployment Compensation Office has a form known as UC 1609, which is available on their website and should also be completed and provided to employees at the time of separation. This Form 1609 existed prior to the passage of Act 9, but was updated by the Department of Labor and Industry as of April 2020. So if you would like a copy of our Act 9 template form or any of the Unemployment Compensation Bureau's forms, please reach out to me, any one of our presenters, or to Allison Hurley, and we will be sure to provide you with a copy of those forms. So with that, I'll remind you again that if you follow the principles of stop, drop, and roll, your company will survive the fire surrounding unemployment compensation during this time of pandemic. That's all I have. So at this time, I'll turn it back to Bob McTiernan to wrap up our discussion.
Thank you very much. I think we've received quite a few questions during the time of this presentation, and I thank my colleagues for their excellent outline of the most recent legal developments. Allison, do you have any particular questions, or do you want to me to pose them to the panel?
I can add them, tell you what they are, and we'll start from there. What should an employer do if an employee or customer tells them that they've tested positive for COVID-19?
You want to take an initial cut at that, Albert?
Sure. I'll start with the employee side of that example. So if an employee advises an employer that they have tested positive for COVID-19, there's been a ton of guidance. That guidance has evolved in the 7 or 8 weeks since most of us have been affected by these stop work orders. The general guidance should be consulted. Bob mentioned in his early part of the presentation, health departments, the CDC. There's lots of guidance out there in terms of quarantining, requiring people. You certainly can require people to not come to work. There can be industry-specific issues. If you work in healthcare, for example, there's separate guidelines that are out there with respect to that. But certainly, first and foremost, when it comes to securing and maintaining the health and safety of your workplace, if you have someone who is still in a contagious stage, you absolutely can and should make sure that they do not come into contact with work or employees. That's obviously pretty easy. But like most issues related to coronavirus, there's more than one consideration. You also have to realize that when an employee advises you of a health condition, which COVID-19 certainly is, generally speaking, employers have a duty to employees to keep private information private. It's pretty uncontested that information regarding someone's specific medical conditions, diagnoses, treatment, etc., is private information. So while you're addressing the concerns of others, you have to make sure that you do so in a way that doesn't violate the privacy of that particular employee. I get a lot of questions about situations that are short of that. So what if an employee isn't sick, hasn't been diagnosed with COVID-19, but is known to have come into contact with like a family member or someone they share a household with? That's slightly different because that type of information about that employee isn't as protected as if it's the employee's condition. So you oftentimes have to balance kind of more than one consideration. You want to secure your workplace. You want to make sure you implement all the accepted medical and scientific guidelines about isolation. You want to obviously, there's lots of specific guidelines about cleaning out workplaces if there's a known exposure. Those are quite specifically detailed in lots of online sources of information. But while you're doing all of that, make sure that you understand and carefully address privacy issues. Typically, privacy issues can be dealt with by not sharing the most private information. So indicating to people that a coworker has been diagnosed and the coworker works in this area and has used this equipment in this time period. Those are factual things that don't betray the person's name or any specific information that is the most privately sensitive and private type of information. There's no typical need to tell folks who aren't folks that have come into contact or will come into contact with that person. So if someone in the Dubuque office has been diagnosed, there's a real question about whether it's necessary to tell somebody in the Portland, Maine office. It's a balancing of those interests. So I think that's a good starting point. Now, in terms of the second part of that question, so you don't have an employee, you have a customer, for example. That's a different legal realm, of course, because employees are the ones who have the most rights. They're the ones that are subject to protection of employment laws vis-a-vis employers. So what we then have is a more generic idea of making sure that our employees who may have come into contact with that customer are aware of it to the point where they can seek appropriate medical care or attention or give accurate answers if they're questioned about their exposure. But those situations are somewhat different because the person who's affected isn't an employee. So those are my 2 cents. I'm sure some of my fellow panelists may want to weigh in from there.
One of the things you point out is the really delicate balance between preserving confidential medical information at the same time, the sort of unusual circumstances of this particular crisis we're in, that we have to make some of these inquiries and we have to take action. So it is a delicate balancing act.
Yeah, and I think one of the very important things, obviously, is the disinfecting and the cleaning. Once you're aware, if you can trace back where that customer or client was at or where that employee was at, the recommendations out there is to do thorough disinfecting and cleaning of those sites with disinfectants, opening windows, using ventilation to try to make sure areas that may have been in contact as soon as you know that. And the other aspect is, as Albert said, is if it's a customer, is letting the employees who were in contact, if the customer is good enough to let you know, so that they know and that they can take see their doctor, be on the lookout for, any potential problems they might have.
Okay, sort of building on that question is another question I have was, may an employer require an employee to self-report on a daily basis as to whether they're ill? And can they indicate that if they provide a false answer, that can end up with disciplinary action?
This
Albert,
Go ahead. Go ahead, Albert.
Oh, sure. The general answer is yes, and this is probably a good time to remind everybody here that this webinar is for information purposes, for providing general information. We obviously can't give specific legal advice without knowing all the specifics that somebody might be facing, but generally, yes. Generally, particularly now, the EEOC and other agencies that care about this stuff that usually are very vigilant about employers being able to gather medical information or conduct de facto examinations of employees either prior to hire or prior to coming to work. All that's been dramatically relaxed given the extraordinary circumstances. So the law permits more than it ever has things like taking of temperatures and asking people to whether they've been diagnosed or tested positive and all of that. However, that's not a license to run amok. And so employers still have to be very disciplined about that. One key way to be disciplined is always kind of stop from a functional perspective. So if you're seeking temperature taking or other information, tie it to the specific things that trigger action. So as all of us, Bob and Scott and I have talked about, there's lots of guidance out there about if someone tests positive, there's recommendations or requirements in terms of cleaning and self-isolating and quarantining. If you ask things, information, and limit your questions to answers that will allow you to discern whether or not there's a obligation or requirement or recommendation that you have to follow, then you're much cleaner than if you look like you're gathering information that the answer to which doesn't put you in a direction of having to do something. So it should start and end with kind of what we've all talked about is if there are requirements in terms of quarantining, cleaning, isolating, ask the questions and only the questions necessary to determine whether you as an employer trip one of those waters.
Okay, I have another question.
Go ahead.
If someone requests FMLA leave because their children are at home and they're doing homeschooling, are they still eligible for leave after the time when the school year would have normally ended?
So if we're talking about the FMLA, the expanded FMLA under the Families First Act, it's true that expanded FMLA covers and protects and gives people FMLA rights like other FMLA leaves, and in addition, pay if they meet the definition of that narrowly drawn criteria. So the language for the expanded FMLA part of the Families First Act talks about if an employee needs a leave because they are unable to work or telework due to a child being to care for a child who is home either because of school's closed or their child care is unavailable. So if they meet all those requirements and if there is otherwise work for them, which means that the reason that they're not working isn't because they were previously furloughed or some other non-extraordinary event condition, then they would fall within that, and you would go through what you kind of normally go through in terms of the FMLA process. Now, I know there's a lot of information out there. I will say that my colleague Kate Cooperwin and I did an article about the updates on the Families First Act and specifically talked about this type of situation, and we gave sample forms. If you're interested in that, feel free to visit our website. Our website is populated on its first page as a link with a ton of information about a lot of COVID-19 related topics, including this one. Go to www.tuckerlaw.com and look for an article that was March 31st on the Families First Act.
Okay, I have another question. Can an employer issue work rules that include an obligation to follow office protocols on using certain areas, wearing protective equipment like masks, as a condition of employment? And can an employee be disciplined or discharged for refusing to comply?
This is Bob McTiernan. I definitely think that work rules will be adapted to this particular circumstance. As with all work rules, it's very important to make them clear, promulgate them, make sure employees are aware of them, at least acknowledge receipt of them, and when enforcing them where possible, except for the most serious type of violation, to follow progressive discipline to protect yourself from claims of discrimination, or also to protect yourself from having to give unemployment compensation for not discharging for willful misconduct. So I think in general that office work rules will be adapted to cover these new circumstances and to require people to really take these protocols seriously. That's my thought on it. I don't know if my colleagues have anything to add.
Yeah, but I'll just add on top of what you just said is it is worth knowing if someone is claiming an inability to follow that rule due to their own health condition. For example, some people may say, I can't wear a mask because I have an underlying respiratory issue, or I can't do XYZ because I've got a health condition. That will sound familiar. That would fall into the category I discussed earlier, is making sure that you have followed through on your ADA issues if someone has a condition that meets the standard of the ADA, and then if it does, that you go through the interactive process and grant a accommodation if it's reasonable.
Great.
What else?
Now, Bob, would the answer be different for a unionized workforce?
Well, I think the difference would be that if there's going to be discipline or discharge, potentially a notice to the collective bargaining representative, the union, the association, in advance, with the notification the rules are going to be adopted, an opportunity for the union to have input would prevent any allegation of an unfair labor practice. But I don't think the union necessarily would have to consent to those rules. You just have to engage, and it is a little bit of an interactive process. And some of the same points were raised before about promulgating the rules properly and making sure people have notice of them would still stay in effect. And then, of course, the concerns Albert raised about people who might have a health concern, those have to be taken into account whether you're in a union or non-union environment. So basically, yes, just with the extra step that you should bring the collective bargaining representative into the dialogue.
This is Albert. I think Scott made an excellent point in his part, where even if you are not in a union environment, please make sure you understand that if more than one person acts together collectively in a concerted way to raise an issue about safety or health, for example, that's protected activity even if a union isn't there. And most of the obligations that an employer would have in a union environment in terms of non-retaliation and so forth would apply as well, even if you don't have a union.
Okay, we have a question regarding guidance for employees who are returning from vacation or perhaps business travel to areas that have a higher incidence of COVID-19 or traveled by air or something like that. Can businesses create a new policy or an exception to an existing policy to effectively limit employees and travel risks on the business?
This Bob McTiernan, I think that is a possibility. It reminds me of the of employers who currently have policies regarding outside employment. So I think that they would have to be prospective, and I think they would have to be rationally based on the needs of the business. Now, of course, if you told someone they can't return to work after a vacation, they might file for an unemployment. But I don't think you necessarily are powerless as an employer with respect to any conduct the employee takes on work time, off work time. That's at least my own view. That might be idiosyncratic, but I don't think employers are powerless in that circumstance. Anyone else? That's kind of a novel one.
Well, the only thing I would caution is I wouldn't necessarily, because an employee took a airline flight to Hawaii or Florida, you can catch coronavirus in a lot of different places. You can catch it at the gas station 2 blocks from your house. So, I just think you want to be careful that you're not casting too wide of a net. Certainly you might, want to keep an eye on that employee when they come back, and you are now allowed to take temperatures, which used to be completely forbidden, but they've really loosened up on your ability to do things like that. So I don't know, though, that you want to have a set policy that if someone flew on a plane, they're not going to be allowed back in the office place. I don't know. I think that could be a little bit,
overly
a little bit of, yeah.
Okay, Bob, I think
Any other questions?
That's all we'll have time for, given everything else. And what we can do is, for the people that answered questions that we didn't get to or more detailed, someone will get back to you with an answer to your question.
Okay, great idea. Thank you, Allison, for the questions, and thank my colleagues, Albert Lee, Scott Leah, and Catherine Janosko for their contribution today, and especially for our participants. We appreciate you joining us. Please note that we are holding 2 more sessions, one on May 21 and one on June 4th, and we'll be sending out invitations again to everybody who's on this call and in this conference, or you could register using a link from our website. So topics are going to be determined by what's happening in the next couple of weeks, and so that session will be timely. You might also want to view information on our COVID blog at www.tuckerlaw.com. That's www.tuckerlaw.com. And as Albert mentioned, we have a lot of information we think are valuable to employers, and Attorney Janosko also mentioned some of the things that are available on that site. So one of the key publications is COVID-19 Answers to Business Challenges, which we think might be particularly helpful. So again, thanks to our presenters today and to our participants, and hope everyone is well and stays safe. Thank you.